Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City. I don't see anyone in Las Vegas yet, but also to those watching online through YouTube or through Nellis. And with that, Committee Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Marzola. Present. Moore. Here. Nadeem. Present. Orentlicker. Here. Roth. Here. Urick. Here. And Chair Miller.
Here. And with that, please mark Assemblywoman LaRue Hatch present when she arrives. With that, just a few housekeeping issues. Just want to remind everyone to please turn off their electronics. Okay, mine are off. I will give the phone number right now with the meeting ID for anyone wishing to call in to make public comment or testify on a bill. The phone number is 888-475-4499, and the meeting ID for today is 816-315-58081. We will have two bills in a work session today. With the flow of the meeting today, again, I ask that everyone, please, anyone presenting a bill, please make sure you keep your comments to 2 minutes each. I'm sorry, that's going to be some quick bills. If you're presenting the bill, please keep your comments to the presentation to 15 minutes each. And anyone testifying or making public comment today, please keep your comments to 2 minutes each. Again, anyone speaking, please make sure to state your name and please spell it the first time so it is correct on the record. Also, I have been neglecting to mention, but if you've noticed, and in other committees, we sometimes have members that are getting kind of coming and going. That's not a thing of disrespect. That's that members have other committees that they're presenting bills in and such. So with that, I think we're ready to begin. I will say that we are rolling one of our work session items, 197. We will work session that on Monday, but with that, we're going to go ahead and begin our work session. So I will hand it over to Policy Analyst.
Thank you, Chair Miller. For the record, Cesar Magrejo, Committee Policy Analyst. As nonpartisan staff for the LCB, I can neither support nor oppose any of the measures that come before this committee. The first measure on the work session today is Assembly Bill 149, which is sponsored by Assemblymember Carter and was heard by this committee on February 26, 2025. Assembly Bill 149 requires the Cannabis Compliance Board to adopt regulations establishing procedures to share information and data for the purpose of research relating to cannabis and the cannabis industry. There is an amendment that was submitted by Rihanna Durrett, Director of the Cannabis Policy Institute of UNLV, which proposes to amend Section 3 and Section 4 to clarify that the funds appropriated are to be used for direct costs associated with research salaries, stipends, project-related travel, and materials essential to research, not indirect costs or overhead expenses.
Members, are there any questions? Not seeing any, I will entertain a motion to amend and do pass. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assembly Member Gonzalez. Any additional questions or comments? Okay, with that, all those in favor? Aye. Anyone opposed? Okay, and the motion passes unanimously. I will assign that floor statement to Assembly Member Carter.
Thank you, Chair Miller. The next bill on the work session is Assembly Bill 150. This bill is sponsored by Assemblymember Orentlicker and was heard on this committee on February 20, 2025. Assembly Bill 150 extends existing prohibitions against directly or indirectly threatening or intimidating certain public officials to include tribal judges of federally recognized Indian tribes or nations, all or part of which are located in the boundaries of this state. There is an amendment that was proposed by Assemblymember Orentlicker, which is to expand legal protections for tribal judicial personnel by prohibiting threats or intimidation against them, including them under the definition of officer granting confidentiality and alternate address protections for personal information, standardizing terminology for tribal judges, and adding definitions for Indian tribe and judicial personnel based on federal law. And Chair Miller, that's all the amendments.
Thank you. Members, any questions or comments? Not seeing any, I will entertain a motion to amend and do pass Assembly Bill 150. So moved. I have a motion from Vice Chair Marzola. Do I have a second? Second. I have a second from Assembly Member Moore. Any additional comments or questions? All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will assign this floor statement to Assembly Member Ornlicker.
Thank you, Chair.
You're welcome.
Thank you, Chair Miller. The final bill for this work session is Assembly Bill 192, which is sponsored by Assemblymember Backus, and it was heard on February 21, 2025. Assembly Bill 192 enacts Uniform Easement Relocation Act and Uniform Mortgage Modification Act. And there is an amendment. So Mackenzie Warren K., representing the real property section of the State Bar of Nevada, proposes amendments to revise and define terms related to easements, clarify restrictions and procedures under the Uniform Easement Relocation Act, expand responsibilities for relocation expenses, and adjust notification and recording requirements for easement relocations. Chair Miller, that's all the amendments.
Thank you for that. Members, any questions? Not seeing any, I will entertain a motion to amend and do pass. So moved. I have a motion from Vice Chair Marzola, and I'll take a second from Assembly Member Cole. Any additional questions or comments? All right, all those in favor, please say aye. Aye. Anyone opposed? Okay, the motion passes unanimously, and I will assign this floor statement to Assembly Member Backus. All right, and as I stated before, we will roll Assembly Bill 197 till Monday and work session it then. With that, we will move on to the next item on our agenda, which is Assembly Bill 91. Assembly Bill 91 revises provisions relating to parole. And Assembly Member will give you a few moments to get settled, and then whenever you are ready, please proceed.
Good morning, Chair Miller and fellow members of the Assembly Committee on Judiciary. My name is Erica Roth, E-R-I-C-A-R-O-T-H, and I'm proud to represent Assembly District 24 in Washoe County. Thank you for the opportunity today to present AB 91, which revises provisions relating to parole by authorizing review by the Board of Parole Commissioners for certain individuals sentenced to lengthy prison terms. This bill comes from a recommendation of the Joint Interim Standing Committee on Judiciary from the 2023-2024 interim and reflects a growing national momentum toward addressing excessive sentences through second look reviews. Second look review provides an opportunity for the Board of Parole Commissioners to reevaluate lengthy prison sentence after individuals have served a significant portion of their time and have remained committed to their rehabilitation. This approach recognizes two important policy considerations this body has adopted. First, that incarceration can be an opportunity for people to change and should be used as a tool towards rehabilitation. And second, that we as policymakers have also changed in our approach over time and recognize that creating pathways to rehabilitation is an equally important factor when considering public safety. At the committee's February 2024 meeting, Daniel Landsman, Vice President of Policy for Families Against Mandatory Minimums, testified that second look review allows decision makers to assess whether a sentence remains necessary, granting discretion to reduce or uphold the sentence based on rehabilitation and public safety concerns. Excessive sentences have long been a driver of mass incarceration in the United States. However, research shows that lengthy prison terms often fail to reduce recidivism and disproportionately impact young offenders and communities of color. By providing an opportunity for review, AB 91 aligns Nevada with national efforts to address these inequities while recognizing the potential for rehabilitation. Additionally, research shows individuals tend to age out of high crime years as they mature, making extended incarceration less effective in reducing recidivism. Second look policies also recognize this developmental difference between youth and adults, aligning again with national reforms that provide greater opportunities for youth offenders. This bill ensures that public safety remains paramount by ensuring our resources are being allocated towards our highest risk offenders while offering eligible individuals an opportunity for release based on rehabilitation and readiness to reintegrate into society. By expanding current eligibility criteria and establishing clear procedures, AB 91 promotes fairness while reducing unnecessary incarceration costs. Before I walk through the bill, I want, with the chair's permission, to just give a brief illustration. I represented a client once at a parole hearing who had been sentenced as a habitual criminal over 30 years prior to his hearing for 3 instances of theft. Not robbery, not burglary, but theft. And in each instance, he was convicted of stealing a little over $200 worth of goods, which at the time was the felony threshold. So he remains for the rest of his life with a tail on his sentence, meaning that until the day that he dies, he will remain under the custody of the state. What this legislation would do is allow him to ask the board to consider that over the last 30 years, he's stayed out of trouble. He served his time with respect for the institution. He took every opportunity that was offered to him while incarcerated to work towards his rehabilitation and was ready to fully integrate into the community without oversight by the state. Moreover, while my client has evolved and matured over the last 30 years, so have our laws, and so has this body and its understanding of the justice system. This legislation allows for all of that to be simply reviewed by the board. Now, with the chair's permission, I'll walk through the sections of the bill and just want to confirm that all members have a copy of the amendment.
I'll also say that we just realized this morning the amendment had not been posted on Nellis yet, so there will be copies over there as well for anyone in the audience.
Thank you, Chair. So now to walk the committee through the key provisions of AB 91 and highlight the changes proposed by the amendment. Section 1 is the central piece to the bill and includes several important elements. First, it authorizes the Board of Parole Commissioners to grant second place review, formerly referred to as second look parole, for individuals convicted of Category A or B felonies under very certain circumstances. For Category A felonies, the individual must not be serving a life without parole or a death sentence, must not pose a significant risk to public safety, and must have served at least 25 years of their sentence. For Category B felonies, the individual must not pose a significant and articulable risk to public safety and must have served at least 15 years of their sentence. Second, it establishes procedures for initiating the second place review through written applications submitted by prisoners, attorneys, family members, or other representatives. The board must verify eligibility within 15 days of receiving an application and schedule a hearing for eligible individuals. Third, it requires the board to conduct second place review hearings in the same general manner as other parole hearings and to prescribe terms and conditions for those granted release. The amendment revises Section 1 by making the factors considered during second place review optional rather than mandatory, allowing for flexibility while maintaining a structured framework. These factors include the consideration of the individual's age at the time of the offense and relevant research on how aging impacts behavior, the prisoner's conduct while incarcerated, including any disciplinary actions taken and completion of educational, vocational, and rehabilitation or treatment programs, victim impact statements, evidence indicating whether the imposed sentence was inconsistent with public policy or state sentencing laws, regulations, or guidelines, whether a stable release plan exists, community or family support available upon release, and any additional evidence deemed relevant by the board for determining whether release would benefit society or pose a danger to society or the prisoner. Lastly, Section 1 includes procedural safeguards to ensure fairness and transparency in the second place review process. If denied, prisoners must wait at least 24 months before reapplying unless otherwise authorized by the board or requested by the Department of Corrections. For those granted second place review, the board sets the terms and conditions for release, and compliance is supervised by the Division of Parole and Probation of the Department of Public Safety to maintain public safety. Section 3 expands eligibility for parole under existing statutes from individuals convicted of offenses committed before age 18 to those convicted before age 25. And finally, Section 4 provides that provisions in Section 1 and 3 apply retroactively to offenses committed before, on, or after January 1st, 2026. As noted, the proposed amendment, just to make clear, makes several changes. One, it replaces second look parole with second place review, and this is really important because it highlights what this really is it's an opportunity for the board to consider all of these factors. It does not require release. It is not any mandatory release. It simply allows the board to take some second place reviews of these individuals who have been incarcerated for a long time. 2, it authorizes rather than requires the board to consider prescribed factors while determining eligibility. This again is important. The board does this all the time with parole releases. So to allow them that discretion in, they've followed some of these folks for a long time before they reach these hearings. And so they do have intimate knowledge of their cases, how they've done while incarcerated and all of that. And then 3rd, it revises factors considered by eliminating specific language related to involvement in crimes, background characteristics, and sentencing enhancements. And with that, Chair, I will turn it over with your permission for questions.
Thank you for that. And I'd just like everyone to know I'm actually not sick. I'm actually just choking on my coffee, and I have no voice because of all the inconsistencies and fluctuations in the weather. So my vocal cords do not like them. With that, yes, I will open it up to questions. Our first question will be from Assembly Member LaRue Hatch.
Thank you, Chair. Thank you for presenting this morning. So my question is, can you just speak to the ways that this bill balances this need we see for rehabilitation with the rights of victims and allowing them to still have a say in the process?
Erica Roth, for the record, Chair, through you to Assemblymember LaRue Hatch. Thank you. Yes, and thank you so much for that question. I think that was considered very carefully in this legislation, and there's 2 safeguards that are put in place. Number 1, it is the Board of Parole Commissioners are required to consider victim impact statements. So that's number 1. But number 2, Marcy's law does require that victims receive notice and have a reasonable opportunity to respond or appear for any significant hearing in a criminal case. And that would include a parole board hearing where there was a potential for release. And so that is a constitutional amendment. The victims' rights are still very much considered in this piece of legislation, and there is no scenario in which an individual will go up for parole review and a victim will not be informed or have an opportunity to provide input to the board.
All right, next question is from Assemblymember Gray.
Thank you. Thank you. Good morning. I'm just wondering, when a sentence is handed down, it's handed down according to law at the time, but it seems like we're always going back to reevaluate the law, which it's not always a bad thing, but we've got so many different areas that we can challenge sentences now. Do we really need another one?
Erica Roth, for the record, can you clarify your question?
Yeah, you can go back. You can appeal your sentence. There's a direct appeal. There's a post-conviction petition. You can motion to modify a sentence. I mean, there's a lot of different avenues you can go through with your attorney. It just seems like we're just adding more and more ways to challenge what at the time is a fair sentence.
Erica Roth for the record. Thank you so much for that question. And I think that's a fair question, right? There is a long process that an inmate or defendant can seek through appeal, but that's really different. You know, that is challenging the legality or any constitutional issues within a case. This is really taking a different approach with saying this person very well in many cases may have pleaded guilty or admitted to the crime and taken responsibility. But we as a body and legislators have realized that, you know, placing somebody in prison for extreme amounts of time does not necessarily meet the public policy goals, especially when they have been rehabilitated, which is really what we are seeking to do for a lot of individuals. Now, this also carves out, you know, individuals who we really have deemed are able to be rehabilitated. This does not consider cases of life without parole or death penalty. And so it is a very specific group of individuals who we're considering here. I'll also note that there is already an avenue for individuals who are over the age of 65 to seek very similar relief. So this is just expanding that, considering that, you know, that same amount of time can pass if a crime was committed, let's say when an individual was 14 years old and now is looking at being released, is serving time in a adult prison, is now looking at being released in her late 30s, you know, is there a period of time within that where she has been rehabilitated and can have the parole board take a look at that sentence and see if it was just and right, even if it was legally sound?
Thank you so much. Our next question is from Assemblymember Moore.
Thank you, Chair, and thank you for the presentation. I really appreciate you sharing that story with us. As someone who works in appeals and you've worked so many different cases, are you able to provide us with other examples where this bill, for the types of people this bill would apply to?
Absolutely, and I appreciate that so much. You know, our philosophy and our understanding of even just the habitual criminal law has changed so much over time. The legal thresholds to meet felonies in different cases has changed over time. But I think that the most compelling story is something that many of the new members on this committee saw firsthand when we visited the women's prison in Southern Nevada. And, you know, there's an individual, a young woman, who is serving a lengthy prison sentence, but she was only 14 at the time of the offense. And so, you know, this just brings before the board an opportunity to consider this person's frontal lobe was not fully developed. What were their circumstances leading up to the offense? And have they reached a new stage in life that they no longer pose a public safety risk to the community, but they've also shown through their incarceration that they have been rehabilitated. And those are the things that are going to go before the board for them to consider, such as what programs have they engaged in while incarcerated, have they attended school, have they taken all of those opportunities, have they done the therapeutic methods that are provided, and all of that. And just saying, you know, we have cases, that is not a singular case. We have a lot of cases where there especially are juveniles, young kids who are serving lengthy sentences. And there does come a point in their life where I do think we have a duty to say, how far has this person come, and do they deserve just to have some review of how much work they have done while incarcerated?
Thank you. Our next question is from Assemblymember Hardy.
Thank you, Chair. Thank you for asking our questions today. So I want to specifically ask, in Section 1, 2A through E, there's 5 separate classes of persons that can file a petition. And then in Section 111, it allows that for a petition every 24 months. So if you could just clarify for me that potentially the parole board could be looking at the same person, that same offender every year, and then that would also require the victim to go through this process again every year. So if you could just clarify that for me.
Erica Roth for the record, thank you so much for that question. Yes, so it does put limits on the amount, and sorry, to clarify, are you looking at the amendment?
Yeah, so I'm just trying to get clarification about how many times, like, the same offender could be going through the process, and then the victim would also have to go through the process. That's basically what I'm trying to get at.
I understand. Erica Roth for the record, thank you. And so it's not 1 year. If an inmate may seek this relief, but if denied, they have to wait 24 months before reapplying. So it's 2 years. And I will say that once, generally how a prison sentence works is, let's say that somebody was sentenced to 24 years to life in prison. Once they've reached that 24 years, they're allowed to start seeking parole. And so they would be going up for those reviews anyways. And so this isn't a huge change after there's been a lengthy sentence that has been served. I don't know off the top of my head, and I'm happy to look into that, or we can ask legal, how often an individual can seek parole once they've served their minimum sentence. I know the chairman of the board is here as well, but this limits it to 2 years, and that is a guardrail that's put in place. But that already exists. That process already exists for those parole hearings.
And just so you know, Ms. Okrent is looking up the response to you right now, or the response, but to get clarification. So we will move on, give her some time to look it up, and move to Assemblymember Hanson.
Thank you, Chair, and good morning. So my question, as I'm looking at the amendment, in Section 1, I'm just going to deal with Sub 1. You made mention of geriatric probation, or parole, I should say. And so as I'm looking at this, and it's also mentioned in the Legislative Digest, the geriatric reference. So in the section in the sub 3, has served not less than 25 years of the minimum term or minimum aggregate term, and so on. If a person has been given a sentence of 40 to life, or now we're going to consider maybe a 15-year change, and within that, down below, it says, does not pose a significant and articulable risk to public safety. So if somebody's been given, say, 40 to life, we know it's pretty darn serious. And so for me, I'm curious, with the geriatric provisions, there are a bunch of exceptions, because these are crimes against children, crime of violence, a sexual offense, vehicular homicide, and so that reference of geriatric parole, and then this is causing me some confusion, because how do we prove significant and articulable risk to public safety, particularly if it was crimes against children, because those that are incarcerated aren't around children. So they might be on good behavior, but then they get out in the regular population. So I don't know how we articulate that they're not going to be a risk to the public.
Erica Roth for the record, and thank you so much for that question, and I think it's a fair one. A lot of care went into crafting language that really considered and took into account public safety. And one thing that I think is important to remember, that when we're talking about murder, sex assault, crimes against children, those cases are very often charged as life without the possibility of parole. And so they wouldn't qualify for this in the first place. Now, if for some reason an individual who had committed a sex offense were to come up for review on parole, which is already something that happens, right? We already grant parole to people who have committed sex offenses. There are very strict guardrails put in place, including risk assessments that have to be considered by the board. It's required to have more of the board members present for those reviews. But I think it's something that's important to consider, and we are happy to really, continue to massage the language to consider those kind of guardrails. The intent of this is not, a get out of jail free card for an individual who's committed a crime against a child, right? What we're talking about here is recognizing that there are crimes that are committed, especially when people are very young, that deserve just a review by the board. There's no mandatory release, but just an opportunity for the board to review those cases and see how they have done while incarcerated and if they have reached the goals of rehabilitation.
Thank you. Our next question is from Assemblymember Cole. See how well those cough drops work?
Thank you very much, Chair. So I guess my question is going to be, and we often ask the same question, right? Like, what do other states do, right? And just doing a little bit of research on this, it seems that other states have done this, but they've done it not quite the way that it's being proposed here. Most of it is having to do with judicial review, not something that goes before the parole board. So if you could just explain, what the rationale is for it going through the parole board rather than judicial review, and why it's such a scope, like the big scope. Like a lot of the states are doing something different. They're doing just juvenile offenses or the habitual sentencing, that kind of thing. Thank you.
Legal can respond to that.
Carly Okrent for the record. As was indicated previously, this follows the same process as is followed for geriatric parole, whereby the parole board, the setup is different in this state than in other states, and so the provisions that you see in this bill are mirrored largely after the geriatric parole provisions.
Understanding that, but it doesn't require it to go that way, right? Like there was some thought that went before this, that we want to pattern it off of the geriatric review rather than something else. Is that correct?
Erica Roth for the record. Thank you for that question. Yeah, this is an interim committee bill, so I don't want to speak out of term of, what the thought process was, but it was a consideration by both houses when crafting this legislation and looking at how the law currently exists and what processes are already put in place, that this was an avenue that just made sense for how our legal system in this state is set up. And then as far as the scope, I think that this is very narrowly tailored. It's important to remember that, we're carving out, especially for individuals who are less than 25 years of age, with a recognition of the science and our understanding of when young people's brains fully develop, all of that. And so it maintains very strict guardrails around how broad the discretion is of the board, that they can consider certain information, but the board really knows these folks. When you attend a parole hearing, the board has often seen these folks many times. They know all of the information of the original crime, every infraction or good behavior that's ever been done while they were incarcerated. Their files are extensive, and so they get to know these people as well, and so we didn't want to limit and say you must consider certain things, but they really have a breadth of knowledge when it comes to these folks, and so we wanted to make sure that they maintain that discretion in being able to consider everything, and that includes, some things that are just not going to work out for people, right? If they have risk assessments coming back that are showing that they are a high risk to reoffend, they're not going to be released.
Thank you. Our next question is from Assemblymember Urick.
Thank you, Chair, and thank you for taking our questions. On the geriatric, because I keep hearing that one come up, that's been in place for a little while, and seeing is that we're trying to kind of model this program after that to some extent. Do we have any success stories or challenges that we've experienced through administering that program that might help kind of inform how we might want to alter or amend this one? And if Chair would indulge a related age question on that, because my question was too related, that 18 to 25 is a significant policy shift as well. The rationale kind of behind that, if Chair will allow that question.
Are you clear what the question is?
I think so.
Assemblymember Urick, what is your question?
If there's any lessons learned from our current geriatric program that we might, either successes or challenges that we might consider that have been there. And then the other one was just the 18 to 25 range.
Thank you so much for the question. I'm happy to look into that. I am not sure. I don't personally have any, stories of clients that I've gotten out on release based on their age, and so but I'm more than happy to look into that, and I think that we can kind of look at how that has been implemented, and I think that's a fair question and something that we would like to consider when crafting this legislation, because we are trying to be very thoughtful and careful with how we are approaching this. When it comes to the age difference, the 18 to 25, that follows really scientific evidence, right? We understand now that a youth's brain is not fully developed until they're about 26 years old. And so it just becomes one factor that can be considered by the parole board when they're making this review. It is not mandatory. It does not mean that the individual is going to get out. It's just something to consider so that we can look at holistically an individual who has spent a lot of time incarcerated and, understanding that maybe they went in when they were 18 years old, but they took that opportunity to get their high school degree, maybe even get some college credits, do all of the therapeutic courses that are offered, haven't gotten into any trouble, picked up no new crimes, all of these things that often are criteria that are not met by people who are incarcerated. And so it just allows, it's just one factor that can be considered, that there was bad behavior when the person, let's say, was 18 or even 14, but look at everything they've done as they have matured and aged through the system.
Okay, thank you so much. We know that research shows a significant decline in the, I don't know if you say the desire or the ability to commit crimes as we age, especially into our geriatric years. And I was actually here when we changed some of those laws, but I'm going to have Ms. O'Krent respond back to two of the questions that have been asked today, one about the parole and one about some of the geriatric laws. So, Ms. O'Krent.
Carly O'Krent, for the record. Earlier, the committee asked how frequently a person has a rehearing for parole, and NRS 213142 gives you the answer that you're looking for. So you have to receive a parole review at least every 3 years or 5 years, depending on how much time is left on your sentence. In terms of the geriatric parole piece, it's my understanding that as that piece of legislation made its way through this building, the number of people that qualified were carved down and down to the point where there aren't very many people that qualify under geriatric parole. And so the interim committee took that into account and didn't similarly limit this piece of legislation. So they still have the discretion to grant parole without narrowing it from the beginning to only certain categories.
All right, we will return to Assemblymember Cole.
Thank you, Chair. I appreciate the second question. So my question is, it just popped into my brain as you were talking, but you had mentioned that some of these felonies that are like the higher classes, right, that are, more violent or whatever, oftentimes are sentenced without the possibility of parole. Is there any concern that you have that more judges will do that based on this language, just to make sure that those folks don't have this second chance? Thank you.
Erica Roth for the record. Thank you so much for that question. That idea had not occurred to me. That is not a concern that I have, quite frankly. I think that, we have already we didn't see a change when we implemented the geriatric parole. So judges aren't sitting down and thinking, well, there's a possibility that this person could potentially get out of prison otherwise based on geriatric parole. I think that there is a lot of trust and understanding between the parole board, judges, the judiciary, and the state in, how we move cases through the system. But, a judge has a duty to base their sentence on the facts before them. And so I don't find that to be a consideration in this.
Thank you. Assemblymember Hanson?
Thank you, Chair. And again, I just wanted to visit this idea that we're kind of shadowing the geriatric parole provisions. I too was here when that happened, and I remember one of my colleagues actually that isn't here anymore, particularly concerned. There are sex offenses committed by people that are 65 and older. Particularly, she noted one with children, but. In my district is the Lovelock Prison, which I have visited, which has become kind of a specialty prison for sex offenders. And half of the state's population are housed there, which is about 1,800. So I'm just still trying to get comfortable with the idea that under geriatric parole, there are at least 6 in NRS 213.12155. There is, again, a crime of violence, a crime against a child as defined in statute, a sexual offense, a violation of another provision, has not been a habitual criminal. And then this all ties to kind of truth in sentencing. When a victim hears in court that the convicted is going to be sentenced to, say, 25 or, say, 30, because we're talking about, serve at least 25 of a sentence. Now the victim is being told, wait a minute, what you were told in court, it now has moved the threshold downward. They know there's a possibility of parole beyond that minimum. So I'm just concerned about 2 things. No real exemptions as we have in geriatric parole. But then also the truth in sentencing for the victim, now the goalpost has moved. And having to relive the trauma.
Is there a question, Assembly Member? Do you have a question?
Well, that is, how do we justify this bill not having the exemptions that the geriatric parole has, and the victim dealing with truth in sentencing and having to relive it again as underneath the minimum of what they have been sentenced by the court?
Erica Roth for the record. Thank you for that question. I'll go first to the exemptions. As you heard from legal, the exemptions that were put in place basically have made the geriatric parole inaccessible. That being said, there are still many guardrails that are put in place in this legislation, especially around the fact that you are not even eligible if you have been sentenced to life without the possibility of parole, which is, the offenses that you are most concerned about, those are often the resulting sentences. I'll also say, just as far as I think you phrase it as, the moving the goalpost or truth in sentencing, is that this is not a novel idea that we have reconsiderations of individual sentencings, right? An individual can go through the appeal process, they can seek post-conviction reliefs, and then farther down the road, they can seek pardons, commutations, all of those things are, a quote unquote moving of the goalposts, but those are put in place because we have to balance not only that, we're not just balancing public safety, while that is very much the backbone of this legislation and a consideration in this legislation. We're also recognizing that we have made mistakes in the past and that not every single person who is incarcerated deserves to be incarcerated for the length of time that they are incarcerated. And it doesn't always meet the public policy goals that this body has put in place. And so it is simply an opportunity for the board to take a look at those cases. And that is something that we already have and allow in many other instances, including when they normally come up for parole review every 3 to 5 years.
Thank you. Thank you for that. With that, I will go ahead and move on to testimony. We will begin here in Carson City. Anyone wishing to testify in support of Assembly Bill 91? Again, we ask that you state your name for the record and spell it, and also that you please keep your comments to 2 minutes.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, Paloma Guerrero, on behalf of the Clark County Public Defender's Office. I'm going to channel my inner John Pirro and start with a quote from Brian Stevenson. When I say each of us is more than the worst thing we've ever done. Legislation like AB 91 recognizes this. It's a step in the right direction, and we urge your support of this bill.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. I just wanted to start with 25 years is a long time, and I think I'm very blessed that I didn't have to deal with camera phones when I was in my 20s. A lot of people don't have that luck, and their entire lives are on display for everybody. AB 91 reflects the belief that people shouldn't be defined by their worst actions. It gives those who have truly changed, those who have grown up and matured, a chance to prove their potential for a positive contribution to society. 25 years, 15 years is a long time, but this just allows another chance to look at what they've done for themselves while incarcerated, and just giving them a second chance. Thank you.
Thank you. Is there anyone else here in Carson City that would like to testify in support? Yes, you may fill the chairs.
Thank you, Chairman. My name is Edward T. Reed, retired Nevada attorney.
Will you spell your name, please?
Sure. Well, last name R-E-E-D, first name Edward, E-D-W-A-R-D. And I am the Vice President of the organization Advocates for the Inmates and the Innocent. I'm here with the President, Tanya Brown, who has some words as well. On behalf of the advocates, I would like to express the advocates' endorsement of AB 91. Now, this comment relates primarily to individuals who were emerging adults at the time that they committed the crime. And there's quite a few really in the system. I mean, they're now like 60 years old, and they had just turned 18 when they committed a crime, got a life without or whatever. So when the original sentencing laws were crafted and enacted many years ago, as to most of these crimes, there had been no research as to the brain development of the so-called emerging adults, or those 18 to 25 years old. However, over the last 10 or 15 years, there has been a lot of research showing that the brain does not fully develop until the age of 25. So we're particularly interested in getting laws enacted that will allow a second look or second review for individuals sentenced to life with or without parole for crimes committed when these individuals were emerging adults or between the ages of 18 and 25, particularly for those under the age of 21. It's simply a matter of fairness for these individuals. They shouldn't be judged the same way a person who is 35 or 40 years when they committed their crime should be judged, I believe. There have been a few relatively recent U.S. Supreme Court decisions, and particularly Miller v. Alabama from 2012 and Montgomery v. Louisiana from 2016, which recognized that the brains of young people don't develop fully until they are 25 years of age.
Sir, your 2 minutes are up, but I see that you have printed testimony out, so I would ask that you submit that to the committee, and then that way we are able to read your full response.
I have like 30 seconds left.
Okay, but the rules of the committee are 2 minutes, okay? Thank you so much.
All right.
Tanya Brown, TONJABROW, Advocates for the Inmates and the Innocent. Thank you, Madam Chair, members of the committee. We strongly support AB 91. We ask that you pass this bill. And I just want to ditto the previous comments that are made. Thank you.
Thank you so much. Anyone else here in Carson City? Not seeing anyone. Is there anyone in Las Vegas that would like to testify in support for AB 91? Also not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in support of Assembly Bill 91, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 91, please press star 9 now.
Good morning, everyone. CYRUSHOJJATY. Thank you for having me. It's a very important bill, great bill. I will testify in support, ditto, and yield.
Sir, what is your name?
Cyrus Hojati, CYRUSHOJJATY. Sorry, I just woke up recently. Thank you.
Thank you so much. Next caller.
Caller, you are unmuted and may begin.
Good morning. My name is Nicole Williams, WILLIAMS. I am on the board of directors with Return Strong. We want to express our appreciation for the intent behind AB 91, which takes an important step towards recognizing the potential for redemption and rehabilitation within our justice system. Expanding parole eligibility for individuals sentenced as young adults acknowledges the well-documented science on brain development and the ability of people to change over time. Building mechanisms for people to have an opportunity and a hope of freedom is a huge motivator for change. However, AB 91 falls short of fully embracing this principle by including those serving life without parole sentences.
Excuse me, according to the rules of the committee, in order to be in support, that means you fully support the bill 100%. So if you are requesting or wish there were any changes, then I would have to move your testimony into opposition.
Okay.
So would you like your testimony to be, are you in full support of the bill as written and amended, or are you in opposition? Are you still there? Okay, we can move on to the next caller, please. Did anyone else lose their internet connection? Okay. So we may, broadcasting, are you still there?
No.
Okay, so we lost broadcasting as well. So what we, let me ask, hold on. All right, we'll go ahead and recess for a few moments. All right, hello, everyone. I will call us all back into order. And we were in the process of support testimony on the phones. So broadcasting, can you open those lines again, please?
If you would like to testify in support of Assembly Bill 91, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 358, please press star 6 to unmute your phone. You may begin.
Good morning, Chair and members of the committee. My name is Riley Svensson, RYLEY SVENDSEN, and I am the policy specialist with the Nevada Coalition to End Domestic and Sexual Violence. NCEDSV supports AB 491 as we deeply understand the intersections of violence and increased risk for incarceration. Individuals are often incarcerated as a result of their own victimization and trauma. In fact, 75% of women who are incarcerated have experienced domestic violence. And a study of women incarcerated in New York's Rikers Island prison found that most of the domestic violence survivors interviewed reportedly engaging in illegal activity in response to experiences of abuse, the threat of violence, or coercion by a male partner. This bill is a much-needed opportunity for parole boards to provide individuals with a second chance, and we urge you to support it. Thank you.
Thank you. Next caller.
Hello, my name is Larry Plumley, LARYPLUMLEE, and I support AB 91. As someone that was convicted of a murder when I was 23 years old, I had life without, and I was one of the few that was eligible for the Pardons Board. But one of the key notes that the Pardons Board made was there is a difference between punishment and rehabilitation, and I was granted a pardon by a 9-0 vote. I know many people within the Nevada Department of Corrections that are under 25, and I'm not sure that somebody understands the difference between when you're 23 years old, 22 years old, 21, 19, and after you do 25 years or 15 years, you are not the same person. You don't have the same desires, you don't have the same outlook on life. And I urge this committee to understand that the bill as written, I understand the life without is not a consideration. But I also understand that a murder conviction less than life without, 25 years. At the end of 25 years, you are not the same person. I know a person committed robbery and received 60 years for robbery, and he used a toy gun. He should have consideration that he was 18 years old, it was a toy gun, and after 25 years, he's doing more than a guy with a life without would do, because it's a flat 60. And I urge this committee to take this into consideration and understand that under the age of 25, 25 years is a long time. Thank you very much.
Thank you. Next caller.
Hello, my name is Misty Stewart, MISTY STEWART. My son has been incarcerated in Nevada's prison since he was 23 years of age. My son's brain was not wholly developed at the time. He struggled with mental health and substance abuse at the time of his arrest. In no way am I justifying his actions. However, he was sentenced to a lengthy prison sentence. He is currently in the 10th year of his sentence. Altogether, it would be like, 6 to 35. During his first years in prison, he finished all the programs he was eligible for. He went to college, paid for by the family, to do substance abuse counseling. Since he completed all the programs NDOC had to offer with someone with his sentence, He has been in limbo, sitting in a cell with time on his hands. He is not eligible for any other programs until 18 months before release. The second look law would give that opportunity for boards of the court to reevaluate his sentence and other sentences just like his. Something like this would be a game changer for my son. There are many days that my son calls me in tears or almost tears, defeated by prison life and wanting to come home and have a second chance to be part of his son's life. The second look law would give him that opportunity. His son has visited him for the past 10 years in prison, and this bill would allow them to build a relationship outside of prison.
Thank you so much. Next caller.
Anne Marie Grant, Advocates for the Inmates and the Innocent, ANNEMARIEGRANT, calling in support of AB 91. Thank you.
Thank you. Next caller.
Callers, if you have recently joined and has not spoke and would like to testify in support of Assembly Bill 91, please press star 9 now to take your place in the queue. Again, if you have not testified and would like to testify in support of Assembly Bill 91, please press star 9 now. Caller with the last 3 digits, 582, please press star 6 to unmute your phone. Caller 582, please press star 6 to unmute your phone. You may begin.
Hi, my name is Hadassah Devorah Golden, and I'm calling in support of 91. The reason is because long-term incarceration is much more harmful than helping people to get out and to be released, especially if their behavior is proven to be very good. In fact, many of the people that can get out would not only do well in society, but would contribute to society. Also, when long sentences are handed out, it sometimes is done in a way that is not fair and is not, so this is what we're hoping for is individuals to be looked at or second chance and be able to help in society again. Thank you so much.
Ma'am, are you still there? Ma'am?
Yes.
Could you
Yes.
Could you please state and spell your name this time?
Yes, it's Hadassah, Hadassah, Devorah, Devorah, Golden, Golden.
Thank you so much, and thank you for your testimony. Next caller.
Chair, there are no other callers choosing to testify in support at this time.
Okay, thank you. Then I will go ahead and open it up for opposition testimony, beginning here in Carson City.
Good morning, Jennifer Noble, Jennifer Noble, on behalf of the Nevada District Attorneys Association, testifying in opposition to AB 91. As an appellate practitioner, I can tell you that one of many procedural vehicles available to challenge a person's sentence is a direct appeal, and you can challenge the excessiveness of your sentence right after you're convicted. That's pursuant to Silks versus State. With my time, I'll give you 2 examples of how this bill would function in the context of Category A felonies, our most serious offenses such as murder, sexual assault, and kidnapping. These are not far-fetched hypotheticals. These are real Washoe County cases with real victims. Example 1 is William Alfaro. This defendant was convicted of 7 counts of child sexual assault and 1 count of lewdness with a minor under 14. He repeatedly sexually abused and humiliated a 9-year-old girl I'll call Eva. His aggregate sentence for these crimes is 265 years to life. Under Section 1 of this bill, he becomes eligible for parole review after 25 years. The second example is Avriana Enoch. Miss Enoch murdered her 5-year-old stepdaughter, Callie, confining that little girl to a dog crate and starving her to death. She weighed 16 pounds when she died. She was convicted and sentenced to an aggregate term of 36 years to life. Under the rubric of this bill, this offender would be eligible for parole review after 25 years, which is 11 years earlier. One might think this is just parole eligibility. It doesn't mean offenders like these will get out, and it's certainly true that that's not a foregone conclusion. But to ensure that victims will be heard as required by the Constitution, as has been noted during the hearing today, they have to be notified, they have to decide whether to participate, they have to relive these events, and they have to be re-traumatized. Lawful sentences should not be second-guessed every 2 years, each time an offender can file a new petition under this bill pursuant to Section 1, Sub 11. At some point, criminal cases must come to an end. Nevada victims deserve some semblance of peace.
Good morning, Chair. Jason Woodard, Jason Woodard, Nevada Sheriffs and Chiefs Association. In 2010, I was assigned as a lead investigator in a case where a mother, over the course of 1 year, dosed her 3-year-old child with methadone for the purposes of making the child sleepy so that she didn't have to directly supervise the child. This dosing of this lethal drug intentionally led to the child's untimely death. During the course of the investigation and subsequent prosecution, the subject was convicted of child abuse and neglect causing substantial bodily harm and/or death, and was sentenced to a lengthy prison term. This is one example where an offender such as this would be reconsidered and potentially released and also considered not a threat to the public. We ask that you would consider this 3-year-old victim, as she will not get a second chance at anything when you consider this bill. We're strongly opposed to this bill. Thank you for your consideration.
Good morning, Chair Miller, members of the committee. Jason Walker, Jasonwalker, representing the Washington County Sheriff's Office, testifying in opposition to Assembly Bill 91 for the main reason of the victims that these crimes were committed against and the potential for re-victimization.
Thank you so much. Is there anyone else here in Carson City that would like to oppose? Is there anyone there in Las Vegas? Not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Bill 91, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Assembly Bill 91, please press star 9 now. You are unmuted and may begin.
Good morning, Chair Miller and members of the committee. My name is Matt Thrasher, Thrasher, and I am calling in opposition to Assembly Bill 91. This bill seems to exist largely for the purpose of this legislative body's desire to circumvent responsibility for the outcomes of laws it writes and transfer that responsibility onto the executive branch. If it is the desire of this committee to let murderers, kidnappers, sex traffickers, and rapists, violent felons, out of prison earlier, then this body should simply change the minimum sentencing terms already written within the NRS. Rather, though, this legislation circumvents your accountability. It keeps your hands clean to avoid ever being questioned as to why a felon, who was released earlier than the current law allows, raped or killed an innocent member of the public a second time. AB 91 takes the onus away from those we elected to assume such a responsibility and passes it off to a board of 7 state employees, 7 private citizens, and I think this is shameful. If this legislature feels that the most dangerous individuals amongst us should be released earlier, reduce the sentencing laws and let yourselves be accountable for those convicted criminals' actions outside the walls of a prison. Thank you.
Thank you. Next caller.
Chair, there are no other callers choosing to testify in opposition at this time.
Thank you so much. Then I will open it up for neutral testimony, beginning here in Carson City.
Good morning, Chair and committee members. My name is Chris DeRico, CHRISDERICCO. I'm the chairman of the Board of Parole Commissioners. I'm testifying in neutral and want to provide some additional information on this bill in its current form and what its enactment would look like at the parole board.
I'll just ask, are you referring to the current form or the amended form?
Current.
Not the amendment?
No, I have reviewed
Okay.
the amendment as
Oh,
well.
perfect.
Yes, I might call it second look.
Look,
parole,
second
but
look
yes,
amendment, okay.
yes, thank you. Before doing so, I want to provide some examples of different offenses that qualify as Category A and Category B felonies, as they're the two uppermost felony categories in the state of Nevada. Category A offenses, for which we see cases for parole, apply to individuals with crimes such as murder, kidnapping, sexual assault, child pornography, lewdness with a minor under the age of 14, and habitual offenders. Category B felonies apply to individuals who have been sentenced to not less than 1 year, no more than 20 years imprisonment. Some of these crimes include voluntary manslaughter, robbery, assault with a deadly weapon, sex trafficking, possession of a firearm by an ex-felon, arson, luring a child for sex, and DUI causing substantial bodily harm. The language of this bill gives the parole board the power and the authority to override a sentence imposed by a district court judge. We're not even attorneys. This bill allows for the parole board to grant second-look parole to an inmate prior to serving the minimum sentence as determined by the district court, regardless of any plea negotiations or verdict. It will also require the parole board's victim coordinator to contact victims of various serious offenses that their perpetrators will now be considered for parole earlier than projected. If passed, inmates convicted of Class A or B felonies will qualify for parole sooner. This will result in the release of inmates convicted of the offense I already mentioned back into the community earlier than anticipated by the court or the victims, but it will reduce prison population. There have already been some discussion regarding the comparisons to geriatric parole and this bill. In essence, they are procedurally the same. However, there are, as mentioned earlier, exclusions in the geriatric parole bill that are not in this bill. For instance, in geriatric parole, if somebody is convicted of a crime of violence, a crime against a child, or a sexual offense or vehicular homicide, you are not eligible for geriatric parole. However, under this bill, you are. Lastly, in Section 3, in this current statute, which is 213.12135, which is entitled Eligibility for Parole of a Prisoner Sentenced as an Adult for an Offense Committed when the Prisoner was less than 18 years of age.
Okay, Mr. DeSico, I just want for the record that I did give you 3 minutes.
Oh, thank you for that.
I know it goes quickly as well. But I just would like to ask you one question.
Absolutely.
And I realize you may not know it off of the top of your head. We know that parole can be and is denied. Do you have any idea how often in the state of Nevada that parole is denied?
Chris DeRico, for the record. So I can't tell, what I believe I can tell you, and I'm going to go off the top of my head. Certainly you can go to parole.nv.gov. Our quarterly stats and yearly stats are there. I want to say that for the last fiscal year, the grant rate, not the deny rate, the grant rate was approximately 54% for the last fiscal year. I'm close.
That's fair.
Okay,
That's fair.
so
That's why I said I know you probably don't know it off the top of your head.
That's on all cases. That's
Perfect.
correct.
Thank you. But you also told us where to go, so we
Yes.
can kind of. All right. Thank you so much for that. Is there anyone else in neutral here in Carson City?
Good morning, Chair and Assembly. My name is Don Southworth, DON-SOUTHWORTH. I'm the Chief of Offender Management with the Department of Corrections. We are testifying neutral on this bill, and it will have a significant impact on our offender population levels. But what we wanted to point out is that there is a lot of examples of successes relating to offenders that have been given a second look and an opportunity to succeed in the community. There are other states that have done similar legislation, as well as the federal government, which has passed the First Steps Act, which was signed by President Trump in 2018. And that's all I had to say. We're testifying neutral. Thank you.
Thank you so much. Is there anyone else here in neutral? Okay, is there anyone there in Las Vegas that would like to testify in neutral? Not seeing anyone broadcasting, will you open the lines, please?
If you would like to testify neutral for Assembly Bill 91, please press star 9 now to take your place in the queue. Again, if you would like to testify in neutral for Assembly Bill 91, please press star 9 now. Caller, you are unmuted and may begin.
Good morning. My name is Nicole Williams. I do apologize for the confusion earlier. I am on the board of directors with Return Strong, and we are in neutral for this particular bill. We want to express our appreciation for the intent behind AB 91, which takes an important step towards recognizing the potential for redemption and rehabilitation without our justice system. Expanding parole eligibility for individuals sentenced as young adults acknowledges the well-documented science on brain development and the ability to change over time. Building mechanisms for people to have an opportunity and hope of freedom is a huge motivator for change. However, AB 91 falls short of fully embracing this principle by excluding those serving life without parole sentences. This exclusion fails to account for individuals who were sentenced under outdated policies, extreme sentencing practices, who were targeted by racist laws, or who have demonstrated remarkable rehabilitation while incarcerated. Many of these individuals were young at the time of their offenses and have since transformed their lives, yet they remain permanently barred from even the possibility of review. True justice should be rooted in the ability to grow, learn, and contribute positively to society. If Nevada is committed to meaningful reform, AB 91 must be expanded to include all individuals sentenced as emerging adults, regardless of their original sentence. A fair and just system does not preemptively decide that a person is beyond redemption. I urge lawmakers to take this legislation further and ensure that no one is denied the chance to demonstrate they have changed. Thank you for bringing this important legislation forward.
Thank you so much. Next caller.
Hi, my name is Yvonne Everland. It's EFVERLUND, and today I'm here in neutral support of AB 91. Today we stand at crossroads, a moment where we can choose to demonstrate compassion and our belief in redemption. AB 91 is not just about parole, it's about offering hope and opportunities for individuals who have spent years reflecting on their past and striving towards personal growth. Consider this. How many of us have made mistakes in our past, only to learn, grow, and change from them? Isn't that what we hope for ourselves? That is what we should hope for those who are incarcerated. AB 91 offers individuals who have served many years behind bars the opportunity to demonstrate that they are no longer the people they once were. It gives them a chance to return to society as changed individuals, ready to rebuild their lives and contribute in meaningful ways. For those convicted of crimes as young adults, AB 91 provides a second chance to individuals who made poor decisions in their youth, decisions driven by immaturity rather than malice. If we truly believe that people can change, then we must give these individuals the opportunity to demonstrate that they have grown, learned from their past, and are no longer defined by it. However, where I stand neutral is that there is a critical group that is often overlooked in discussions about justice, individuals serving life without the possibility of parole. Many of these individuals have spent decades in prison, yet they are frequently left out of conversations on rehabilitation. But they too possess the capacity for growth and change. AB 91 can provide them with a chance to demonstrate their transformation. Even if parole is not an option, it opens the door for hope for those who have been forgotten, reminding us that everyone deserves the opportunity to show that they have changed.
Ma'am,
By passing
Ma'am,
AB
your 2
91,
minutes
you will
are
send a
up.
powerful
Ma'am,
message
your
that our
2 minutes are
society
up.
values
Next caller.
rehabilitation. Thank you.
Thank you.
Good morning, Chair Miller and committee members. My name is Eden Kinlock. Thank you for the opportunity to comment on Assembly Bill 91. SAM is a nonpartisan, nonprofit organization that seeks to create a more fair and effective justice system. We advocate sentencing policies that are individualized and fair, protect public safety, and preserve families. As part of our National Second Chances agenda, we support legislatures across the country in creating more pathways for long sentences to be reviewed and adjusted through second look mechanisms. Sam submitted written testimony today and comments today to share a neutral stance on AB 91. Second look laws come in many different forms, and we are pleased to see that AB 91 incorporates some very positive features to expand access to sentence modification for individuals serving lengthy sentences. Still, AB 91 is not consistent with SAM's key principles for second look legislation. Broad eligibility criteria is a primary principle for crafting second look policy. Only individuals convicted of category A and B felonies who are not sentenced to life without parole are eligible for sentence review hearings under AB 91. A second look policy with broad eligibility criteria allows decision makers to determine if a sentence is still in the interest of justice and an appropriate use of Nevada's finite public safety resources. The potential fiscal benefits of second look are also the largest if people serving the longest sentences are eligible. The vast majority of people who commit crimes, even very serious ones, naturally grow out of criminal behavior as they age and mature, making long sentences ineffective and wasteful. Second look does not guarantee release. It simply allows decision makers to assess whether continued incarceration is necessary after all the relevant factors are considered. Please visit SAM's website for more information on the principles of second look, and we encourage legislators to continue to consider when crafting these policies. Thank you for your time and consideration.
Ma'am, are you still there?
Yes. I'm here.
Can you tell us the name of who you're representing, and then state and spell your name again for the record, please?
Yes, I'm representing SAM. My name is Eden Kinlock, EDENKINLOCK.
Okay, thank you. Next caller.
Good morning, members of the committee. Hello, my name is Mark Bettencourt, MarkBettencourt. I'm here today representing Nevada Coalition Against the Death Penalty as the executive director, and we are in neutral on AB 91. While we believe that there are some very strong core concepts of this bill and that they are necessary to reduce the incarcerated population, rebuild our communities, and unfortunately, the current language just doesn't go quite far enough. If we all collectively believe in redemption, if we believe in our institutions' ability to rehabilitate individuals, if we believe in the ability of our institutions to accurately assess their ability to re-enter society, then this bill language should include folks facing life without parole. Talking to and working with current and formerly incarcerated individuals, it is obvious that every person has the capacity to change for better. I'm not the same person I was at 20. I doubt the members of this committee are either. As it stands, this policy will help a lot of people, but it can help a lot more. Thank you.
Thank you. Next caller.
Chair, there are no other callers choosing to testify in neutral at this time.
Thank you so much. Then I will welcome the bill presenter back up for any final remarks.
Thank you, Chair. Erica Roth for the record. A few points, and I want to close out with a story of an individual who I represented on appeal. Approximately 15 years ago, he was charged with a string of felony theft-related charges, and while he was after he took responsibility for those crimes, he did pick up another charge while he was awaiting sentencing. And he was sentenced to federal prison for 10 years. When he completed his federal sentence, he was sent back to face the consequences of his state charges for theft-related felonies. And he was ultimately sentenced to prison for life without the possibility of parole. his appeal has been, his case has been overturned on appeal, but I think it's really important to remember the kind of cases that would be considered for this review. It's easy to put into the minds of each and every one of us some of the most horrendous crimes that we can think about. But it's also important to remember that the parole board, as you heard, are human beings too, who have to consider what that original crime was when considering if they would grant that parole. And that is not something, quite frankly, that I can imagine them doing, is releasing certain people like that. I'm happy to take the suggestion or concern by the parole board. More than happy to consider whether or not it's better to have a requirement that their attorney is reviewing these cases in the future. But at the end of the day, this is not a get out of jail free card. This is simply an opportunity for the board, who already makes these reviews on a daily basis, to consider a human being, who they are holistically. What they did, absolutely. The impact that it had on victims, absolutely. How old they were, how much they have changed, what they've accomplished, and whether or not it is a human being who we have deemed deserves to be in prison for an incredibly lengthy sentence. And so this is simply a tool to allow for a very small group of individuals to have their lives reviewed holistically and considered, to see if we as a body who has changed our perspective on the kind of cases that we send people to prison for lengthy sentences, such as drug crimes, such as our habitual criminal sentencing, and say this person deserves to simply have their life looked at one more time. Thank you.
Thank you. And with that, I will go ahead and close the hearing on Assembly Bill 91. Our next bill that I will open the hearing for is Assembly Bill 489. This revises provisions relating to civil actions. And so, Mr. Fitzgerald, I'll give you all a few moments to get settled. And then you may introduce your presenters. Of course, everyone will need to introduce, state your name and spell it for the record. And please keep your presentation to 15 minutes. And then you have someone on Zoom co-presenting? Okay, thank you so much. Proceed when you're.
Thank you, Chair. Martin Fitzgerald for the record, Martin, last name Fitzgerald, Fitzgerald. With me at the dais are Jerry Feynman and Shannon Forsyth, and we have virtually joining us Glendine Grant. As well, we also have two attorneys, Sean Higgins and Kim DeGagna, who are available to answer legal questions during the question time. So with that, I'll turn it over to Jerry.
Thank you, Chair Miller, Assembly Judiciary Committee members. My name is Gerald Feynman, GeraldFineman. I have over 3 decades as a prosecutor working extensively on cases involving homicide, domestic violence, child abuse, drug-related deaths. I also spent over half of that time not just as a line-level prosecutor, but as a manager of prosecutors, which handled all kinds of other cases, including vehicular homicides. I've worked with numerous agencies to help develop policies and protocols in handling these cases. In addition, I became a national speaker, which I continue on in my retirement now, on training law enforcement and working with victim rights groups across the country to provide training on domestic violence, strangulation, victim assistance, and leadership development. That includes here in the Las Vegas metropolitan area, where I conduct an annual seminar. Today, I wish to express my strong support for AB 489 and to highlight for you how the current legal framework denies many families justice, particularly in cases involving DUI fatalities, drug overdoses, and domestic violence homicides. The current statute of limitations on civil actions forces families into an impossible position where they have to make a decision between civil or criminal. because complex litigation takes time to prosecute. Modernly, we have things like DNA analysis, digital evidence retrieval, toxicology reports. In many cases, it can take law enforcement that 2-year period from the time of death to the time a family would have to file before they can even prove a case. Domestic violence homicides, for example, often involve staged crime scenes designed to look like an accident or a burglary. There are lots of examples of this, but probably the most prominent is the Drew Peterson case, where Drew Peterson, a law enforcement officer, committed the murder of his former wife, and it wasn't discovered until his most recent wife went missing. That body still has never been recovered. But it's not just domestic violence cases. You see, human trafficking victims are often murdered and dumped in remote areas, or they are killed in an effort to intimidate other trafficking victims. So those witnesses are fearful of coming forward. Drug-induced homicides require significant investigation to trace back to the source of the controlled substance, back to that distributor. Vehicular homicides require time for accident collision reinstruction, toxicology testing. All of these things have to take place. And even where law enforcement is working as quickly as possible, we still have delays. Because once the case gets filed, these are our most serious cases. The courts have to proceed slowly, even in the light of speedy trial statistics or statutes. Counties like Clark and Washoe have extreme examples of this due to their high volume. The attorneys handling these cases often represent a small population of the bar, both within the defense bar and in the prosecutor's office. This further delays the process. If a family chooses to file early and to file their civil action, if they are at all a witness in the case, that becomes a valid ground for the defense attorney to question their bias in the proceedings, and that can impact the case. I've seen that myself. AB 489 corrects this injustice by extending the statute of limitations on homicides to allow families time to seek justice. I've had the painful task of speaking to parents who lost children to drug overdoses, unable to hold those dealers accountable. I've worked with families of domestic violence and human trafficking homicide victims forced to watch the person who took their loved ones' lives manipulate the system. And even where the verdict is guilty as charged, our criminal justice system sometimes falls short of giving them the justice they need. The appellate process, changes in the law, those kinds of things may impact what looked like a lengthy sentence, and it may no longer let a family feel like their needs have been served in terms of justice. This bill is not about extending lawsuits indefinitely. It's about ensuring that the most serious cases, our homicides, are given the time and attention that they deserve, and giving grieving families the opportunity to hold those responsible accountable, both criminally and civilly, without undermining the prosecution's ability to seek a conviction. I humbly and respectfully urge the legislature to pass AB 489 and remove this unnecessary burden on victims' families. Thank you for your time. I welcome any questions, and if there are none, I will pass it to the next speaker.
We're gonna hold questions until the end of the entire presentation.
Very well. Thank you, Chair. With that, I would pass it to Shannon Forsyth.
Thank you. Good morning. My name is Shannon Forsyth, SHANNON My husband Bartley and I started Rent to Rescue 13 years ago, and we're an organization dedicated to reaching, rescuing, and restoring victims of sex trafficking here in the United States. For years, we have worked with hundreds of young girls, boys, men, and women who have survived unimaginable horrors. We provide trauma-responsive services, we assist in recovery, and we fight for justice. As tragic as human trafficking is, there is no greater devastation than when a victim's life is taken or when they disappear and are never found. We have witnessed firsthand the brutal realities of trafficking: electrocutions, burns, drownings, chokings, severe beatings, and even death. And yet what is often overlooked is the intersection between domestic violence and human trafficking. In domestic violent cases, the abuse typically comes from a single partner. In trafficking, the same dynamic exists, except the partner also exploits and sells their victim. The similarities between human trafficking and domestic violence are undeniable. Both involve an intimate partner as the abuser. Non-compliance leads to consequences, beatings, restraints, threats to loved ones, isolation, and sometimes death. And victims, whether trafficked or in domestic violence situations, lose their sense of identity. While trafficking victims may be branded with tattoos claiming ownership, domestic violence survivors bear visible and invisible scars that still mark them as being controlled. Despite the thousands of confirmed cases of human trafficking of victims in Nevada, we have no clear number on those who have been murdered. Research published in the American Journal of Epidemiology found that women in street prostitution face an annual homicide rate of approximately 204 per 100,000, making it one of the most dangerous occupations. If there are 2,000 to 3,000 trafficking victims in Clark County alone, this suggests that 2 to 6 trafficking victims are murdered in Las Vegas each year. However, these murders are often misclassified. When a trafficking victim is found dead, the case may be labeled as gang violence, domestic violence, drug-related, obscuring the true scope of the crisis. I want to share a story of a young woman named Jessie Foster. Jessie was a beautiful young woman from Canada who came into Nevada. She was young, in search of a fun life, a better life. Instead, she became a victim of sex trafficking. And then one day, she vanished without a trace. Her mother, Glendine Grant, was unable to come to the U.S. due to certain restrictions preventing her from searching for her own daughter. Each time a report surfaced of a young woman resembling Jessie, hope would rise, only to be shattered that it wasn't her. After 19 years of searching, most believe Jessie is no longer alive. So what happens if Jessie's body is found today? What recourse does her family have to seek justice? Jessie is never going to have a wedding. She will never give Glendine grandchildren. She will never celebrate another birthday. While filing a civil lawsuit cannot bring Jessie back, it can force perpetrators to face accountability. And sometimes, this is the only justice a family can get. Nevada's current civil statute of limitation does not reflect the complexities of human trafficking cases or domestic violence cases. Traffickers are skilled at erasing evidence, and so are domestic violence abusers. They're skilled at silencing witnesses and ensuring their crimes remain buried for years, sometimes decades. Families of murdered trafficking victims deserve more time to seek justice. I urge you to support this legislation that extends the statute of limitation for civil lawsuits against those responsible for the deaths of trafficking victims, domestic violence victims, drug addicts, all of them. This extension will ensure that when these cases are finally uncovered, when a body is found, when a witness comes forward, when justice is within reach, the law does not slam the door on a grieving family. Thank you for your time and consideration, and what I would love to do is introduce you to Jessie Foster's mom, Glendine.
Hi there. I am Glendine Grant. I'm the mother of missing Jessie Foster. She was taken from Kamloops, BC, Canada, where she was raised in the spring of 2005. And after a few stops, she landed in Las Vegas on May 13th, 2005. It was exactly 2 weeks before her 21st birthday. We thought Jessie was having a wonderful life, that she had met someone. She got engaged and moved into his beautiful house in North Las Vegas. It was actually not what was happening. She was living in a nightmare that she was too afraid to tell anybody. She couldn't talk to the police. She couldn't talk to us. She was too afraid of her captors. Unbeknownst to us, she was being beaten and forced to work at an escort agency. She was working as a prostitute until March of 2006. During that time, she was arrested for solicitation for prostitution twice, and there were 4 charges in total. Our private investigator also found hospital records that proved she had been beaten. Her jaw was broken, and that was something she never told us. 19 years and 5 days ago today, Jessie went missing. We have not found her, nor have we heard anything regarding her disappearance from anyone who knows the truth in all that time. When a loved one goes missing or worse, the family has many roadblocks that hinder them from getting answers, but it's more than that. We can't work. We have to pay private investigators, offer rewards, travel to different locations, make posters, and everything costs a lot of money. In our case, it emptied our savings account and left us struggling financially for almost 2 decades. My husband and I are both senior citizens, and we both still work out of necessity. We have no golden years coming up. We have no travel plans, and we have nothing other than surviving and ensuring our family is doing okay. And thankfully, we are. Besides financial issues, we also have mental and physical health issues. Jessie's biological dad, Dwight, never got over her disappearance, and at the age of 62, after struggling with heart disease, he died of a heart attack in 2020. Our older daughter, Crystal, Jessie's oldest sister, also had a very hard time accepting that her little sister was missing for so long. Her struggles included drug addiction, and that was the battle she lost in 2021. For myself, the stress I have been under has been great. I'm not only living with a missing child, but I'm also worried about the rest of my family, our financial burden. And on my 66th birthday, in 2023, I had a massive heart attack. I ended up with emergency triple bypass. And strangely, out of all of us, I am the lucky one. I'm the mother with a missing daughter who is a human trafficking victim, and I'm the lucky one. The only thing that has helped me cope through all this turmoil is the fact that Jessie's story has been given voice and inspiration that has helped others escape what might have been the same fate as our poor Jessie. Because, Jessie is everyone's daughter. She's everyone's sister. She's everyone's friend, and even all of yours. Through Jessie's case, I started a grassroots organization called MATH, Mothers Against Trafficking Humans, back in April of 2010. And through it, I try to educate women, families, organizations, and even the police on what to do if you have a missing loved or murdered one in your family. I try to point people in the right direction to help them in the areas they live or where the crime happened, or just whatever I can do to help get them some justice. I was going to say, and closure, but we never get closure. That's just a word that is used. And that's why I'm here today. Ever since Jessie went missing, I have turned my grief into action, advocating for families, for victims, and for change. I've worked with the Nevada Center for Missing Loved Ones, and I've worked on helping victims of the missing and murdered Indigenous women up here in Canada and all over the world, actually. And a few weeks ago, her story was an inspiration for an article just recently, the Review Journal. Jessie has continued to inspire and help people through our actions. And it's been 19 years since she went missing. And under the current law, we would be prevented from seeking justice because of that statute of limitations. There are more victims and families like ours who are denied justice, those outdated laws. I hope you see us in the struggle that our families go through and the need to update the law to help us secure justice and accountability. Thank you for listening.
Thank you so much, and we are deeply sorry for this loss. Thank you, and thank you for being here today.
Martin Fitzgerald, and I'll close by going briefly over the bill. It's a short bill. Section 1 of the bill defines the term heir. Section 1 and 2 of the bill ends the statute of limitations for wrongful death. And Section 3 removes the statute of limitations retroactively so victims of wrongful deaths that have occurred before the passage of this bill are able to bring civil action against the perpetrators of their death. We have a technical conceptual amendment that is posted on Nellis for Section 3 that replaces the current language with language that has been affirmed in case law by the courts as appropriate. And finally, and in closing, I'll note that the Resorts Association had a question on the bill before the hearing, and we're going to have continued conversation with them offline. So with that, we welcome questions.
Thank you so much, and we appreciate that. We know that, especially at this point, things happen kind of quickly and last minute, and so we appreciate that. Just giving members a moment to populate if they have a request for a question. Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. So I want to make some points clear that in the current scenario, if the victim is missing. So what action can be taken against the suspect?
I'll let Sean or Kim, if you're able to answer that question. Actually, I'll ask, do you mean civilly or criminally?
Both.
Jerry, if you want to answer the criminal, and then we'll go to civil.
From a criminal aspect, if the victim goes missing, law enforcement presumably will be looking for them. But until that body is found, the clock is ticking. The statute is triggered by the date of death, not by when the victim is found. So if it takes law enforcement 2 years, 3 years to find the victim, criminally, they may be able to pursue criminal charges, but civilly, the door closes on the victim's family to seek any type of civil relief.
Thank you.
Thank you so much.
Sean or Kim, if you want to just...
Yes, good morning. Sean Higgins, S-E-A-N, Higgins, H-I-G-G-I-N-S. I think he said it correctly, which is the body, in most cases, does not have to actually be recovered to bring the civil action. There are certain presumptions under state law, but regardless of whether the body is found, the clock will begin to run from the actual date of death under the civil statute, and which is 2 years.
Thank you. But that certainly isn't the only instance where this law would apply.
Correct. And Sean, if you want to, go ahead.
These revisions, oh, sorry, was that a question, Chair Miller?
Yes, please respond, yes.
Yes, it will apply to all instances of wrongful death caused by homicide. It is not limited to instances like Ms. Glendine Grant's poor child, where the body has not been recovered or is missing. It will apply to all cases of homicide in which homicide is the cause of the wrongful death.
Thank you for that. All right, not seeing any additional questions, I will go ahead and open it up for testimony. Beginning here in Carson City, those wishing to testify in support.
Good morning, Chair, members of the committee. Tess Opferman here on behalf of the Nevada Women's Lobby. We are in full support of this bill. We think it's a simple, straightforward measure to ensure that families can get justice when someone does die, and we need a longer period to figure out when the body is found. And so we are in full support of this measure. Thank you.
Thank you. Is there anyone else here in Carson? Not seeing anyone? Not seeing anyone in Las Vegas either. Broadcasting, will you please open the lines?
If you would like to testify in support of Assembly Bill 489, please press star 9 now to take your place in the queue.
Good morning, Chair and members of the committee. My name is Riley Swenson, RYLEY-SVENDSEN, and I am the Policy Specialist with the Nevada Coalition to End Domestic and Sexual Violence. We support AB 489, which allows grieving family members to pursue civil litigation in the aftermath of wrongful and violent deaths. The current standard of seeking litigation within 2 years is not victim-centered, nor does it take into account the complexities that go into conducting and finalizing a criminal investigation. Bringing forward a civil claim while a homicide investigation is underway can jeopardize the investigation, and often families are waiting for the investigation to conclude to receive final answers and closure. In 2024, 49 individuals lost their lives due to domestic violence homicides in Nevada. I think it's safe to assume that many of these criminal cases and investigations are still active with criminal procedures pending. The families of these individuals deserve to pursue civil litigation if they choose to, and should not be held to stringent time constraints. This legislation is common sense victim-centered bill, and we urge its passage. Thank you.
Thank you. Next caller.
Chair, there are no other callers wishing to testify in support at this time.
Thank you. Then I'll go ahead and open it for opposition here in Carson City. Not seeing any. Broadcasting, can you open the lines?
If you would like to testify in opposition to Assembly Bill 489, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Okay, then I will open it up for neutral testimony here in Carson City. Not seeing anyone. Broadcasting, please open the line for neutral testimony.
If you would like to testify in neutral for Assembly Bill 489, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in neutral at this time.
Thank you so much. Then I will welcome the bill presenter up for any final remarks.
Thank you, Martin Fitzgerald, for the record. We have some groups that will be submitting some written testimony as well, so we encourage people to look on Nellis for that. And with that, I'll say this is a great bill, and we urge your support and passage. Thank you.
Thank you so much. With that, I will go ahead and close the hearing on Assembly Bill 489. Next on our agenda is public comment. So anyone wishing to make public comment here in Carson City? Not seeing any. Broadcasting, will you open the lines for public comment?
Chair, the public line is open and working. There are no callers to provide public comment at this time.
Thank you so much. Then with that, I will close public comment. And again, thank you everyone today for your work with the work sessions and the hearings. And we will go ahead and adjourn for today. And I will see you at 8 a.m. tomorrow morning.